the SA Government International Legal Relations from the Department of Justice of the Governments of South Africa. And finally, Manrit Kaul, she's an assistant counsel at the ICC, and Brenda Okode, she's a specialist expert in international attorney from Norway, Sweden. Okay, Professor Milton, I pass the text to you so we can continue our discussion of today.
All right, thank you very much, Dr. Marotta, as usual, for that good introduction. Today we are having quite a challenging topic. First of all, I welcome all of you viewers all over the world. We apologize for the small hiccup we had, but now everything is right. We thank you for being there, and we hope you'll be able to benefit from the discourse we are going to have with the professors who are well versed in this area of discourse. As Dr. Marotta has indicated, today we are going to delve into the issue of hybrid justice, looking at it vis-a-vis the International Criminal Court. It's an area that has attracted a lot of attention lately. We had hybrid. Hybrid basically means, as we know in common parlance, means a mixture of more than one thing, two things, two aspects working together. The product of two different methods or mechanisms or systems brought together. And in this context, we are referring to mechanism in the international criminal justice and the mechanism that we have in the domestic criminal justice. So it is a hybrid, a mixture of two. So the discourse that the professors are going to provide today will revolve basically around the system that has been there, that existed prior to the coming into existence of the International Criminal Court. And now we see, again, more and more of the hybrid form of justice showing up. And we're going to look into that in details, and I hope our professors will be able to unveil that to you. We will try to examine largely the historical context of the hybrid. We'll look at what constitutes the hybrid, what inspires it, and how it came, how after the ICC came, there was the thinking, there was a class of thinking that probably the hybrid would now be phased off. But we're seeing that owing to the shortfalls and the constraints that the ICC has been experiencing, especially being overwhelmed with the backlog of cases and the acceptability within certain states. So we've seen that there's a tendency now to get back to hybrid mechanism of justice. I don't want to go into details for now, but just to welcome you and get ready, all the millions of viewers, wherever you are, all over the world. We welcome you to be able to follow this discourse with interest. I hand you back over to Dr. Marotta. Thank you, Dr. Marotta.
Thank you, Professor Milton. I want to make, before passing the desk to Professor Shanawar Shiprati, to make a statement here, because I think it was 2 days ago, the United Nations ended an investigation, and yes, I think it was on Wednesday, 2 days ago, against President Nicolas Maduro of Venezuela. They found that Maduro and his fellow high-ranks ministers, military agents have been implicated in crimes against humanity. So the question here that I bring is, even though Venezuela is part of the ICC, and they have been they ratified it, I think in 2007, or it was in 2001. I don't recall the date that they ratified to be part of the ICC. In 2017, there was it was established the Lima Group, and since that day they have been doing statements of the violations of human rights that had happened in Venezuela. Since 2017 and last year, there have been an exodus of, a lot of the population from Venezuela migrating to Colombia, Ecuador, even Peru, Chile, Argentina, Brazil. Well, Brazil is a border with Venezuela as Colombia, but the migration to other countries that are not part of the border of Venezuela has been in crescendo every day. So the last I'm here. Here I have the statement, the last statement that was June 16 from the Lima Group, that is backbone by the Canadian government. They made a statement rejecting the legal designation of the members of the National Electoral Council of Venezuela through a ruling of the Supreme Court of Justice. Uh, as they have analyzed that, which openly violates the Venezuelan constitution and undermines the minimum guarantees necessary for any electoral process on the return to democracy in Venezuela. Um, I think that since 2017 and up to this Wednesday, what the Lima Group has been doing, pushing in somehow the UN to do the investigations against um, the human rights violations in Venezuela. I think it has its own results. That probably with this investigation, in a couple of months, we will see an indictment from the prosecutor office against Maduro and his government and all part of the other possible perpetrators. On the other hand, we need to understand the in Latin American and in all the North America and South America, since 1950, there is a system that they have that is operating, that is the Inter-American Human Rights Division. They have a court in Costa Rica. However, that human rights court only investigates a court of last resort violations from states against the human rights in general. And they also have a commission. The commission, it has the function of like a prosecutor office, who decides which case goes to the court, which not, and they do all the investigations. So before passing the desk to Professor Shipatri here, my question is, what we are going to see in Venezuela, if Venezuela is going to, Maduro in this case, is going to be prosecuted by the ICC, probably he will try to make a solid defense, not to be extradited to the Netherlands to be trial. And on the other hand, we have over the past, these past 70 years, approximately, in Latin America, as a human rights prosecutor system that have been in somehow working very well. It will wait for a hybrid international court for trialing Maduro in the coming years for the violations of the human rights. Remember that even though the ICC under Roman Statute in the year 20 years ago, they began to operate. Truly, we have seen many hybrid tribunals being made during this couple of years. So that's my question for Professor Shipatri. by his experience. What he sees over here that the ICC is going to prosecute Maduro as he has been prosecuted as the prosecutor office have been accusing other other international criminals, and then follow that accusations to be trial in the ICC, or do you think under the past of these 70 years of the inter-American human rights systems in America uh, will wait for for a hybrid court for trial Maduro? Thank you, Professor Tripati.
Thank you. First of all, Professor Milton, the host of this program, and also Dr. Marotta, the co-host of the International Criminal Justice Program. Now, right from the time the states in the international community realized that serious crimes were being committed by certain heads of states in the world, and that too with impunity, different courts have been established in order to bring the culprits before justice. Now, we have seen during the Second World War, a lot of Nazi soldiers had committed war crimes and genocide and then crimes against humanity. So we had the two tribunals, the Nuremberg Tribunal and the Tokyo Tribunal. A major defect in this, particularly the Nuremberg Tribunal, that was pointed out was all the judges had come from the victorious powers, that is England, France, USA, and Russia. So the accused absolutely had no chance of a fair trial. That was the biggest criticism that was directed against the Nuremberg trial by the international lawyers at that point of time. So also was the case with the Tokyo trial. Then again, the two states, Yugoslavia and Rwanda, there was a lot of crimes that were committed by the heads of states in these two countries. And the Security Council took the responsibility of establishing two ad hoc tribunals, that is the ICTY and ICTR. And these tribunals derived their powers and jurisdiction from the Security Council. And then in 1998 came the ICC. The Rome Statute was signed by a large number of states, 123 to be precise. The Rome Statute was signed and the ICC came into existence and started functioning from the year 2002. Despite the large support that the ICC received at the time of the signing of the statute, when it came to actual functioning of the court faced a lot of practical problems. Because some states which were so eager to establish the court subsequently opposed the court. And US, which was at the forefront of all the negotiations, finally never signed the statute. But despite all these difficulties, the ICC continued with its functioning. And then one particular state, that is Sierra Leone, where there was trouble in that country, and when it came to punishing the head of the state of that country, the government of Sierra Leone uh, entered into an agreement with the United Nations organization for establishment of a hybrid court. Now, one thing that I can say is that hybrid courts probably can be an alternative to ICC, but not all the time, because hybrid courts have their own disadvantages. Because in a hybrid court, the law needs to be applied by the court in order to try the accused is international law and national law. And there could be a clash of provisions from the national law and provisions from the international. Now, the court would be in a fix as to which provision shall prevail. Because if you consider the laws, the municipal law of a country, international law, within a country, the municipal law shall prevail. That is the domestic legislation or the domestic. But in the case of a hybrid court, the court sits on the territory of the state. The judges, some of the judges come from that country, and some of the other judges come from the international system. Now, here again, who shall have primacy, whether international judges or national judges? So, these sort of procedural problems are very much existent in a hybrid court. But nevertheless, Sierra Leone problem was somewhat solved. And as you have been speaking of Venezuela, the problem, whether a hybrid court would work for Venezuela. Now, we do have this Inter-American Convention on Human Rights, where the states belonging to the North American continent and the states belonging to the South American continent are parties to this convention. And with regard to violations of human rights under this convention, we also, like what we have in Europe, we have the European Convention on Human Rights, and under this convention, a court was also established, known as the European Court of Human Rights. So, if any such incident had taken place in Europe, probably the European Court of Human Rights would have, taken up the case and ensured that justice would be done to the states where the problem has come. But we also have this Inter-American Convention on Human Rights. But the problem is whether the states are ready to refer the case to the under the convention to any court, whether the ICC or a hybrid court, is a problem that needs to be addressed initially. Because in the case of Sierra Leone agreed for a hybrid court. And only then it signed an agreement with the United Nations. In the case of Venezuela, hybrid court work provided the government of Venezuela enters into an agreement with the United Nations. And as I mentioned earlier, hybrid courts have their own problems. There are disadvantages and advantages, but disadvantages are more than the advantages. Advantage is that it acts as an alternative to the ICC. The problems that are inherent in the statute of the ICC probably can be overcome by a hybrid court. States may accept the jurisdiction of a hybrid court rather than accepting the jurisdiction of the ICC. That is the only advantage, but disadvantage is more in a hybrid. Because as it was pointed out by Professor, that the very meaning hybrid means it is a mix of two judicial systems. One is a national judicial system and the other is an international judicial system. So striking a compromise, striking a balance between these two judicial systems would be the most difficult task for any country if it is planning to have a hybrid court to try the accused. Now, when I say practical problems such as uh, the knowledge of the law of the country where the court is, probably the national judges of that country will have knowledge of the law. Judges have to be made aware of the legal system in that country because they may not be aware. They come from a different legal system. Or they come from different countries where the law may be different. That is one. And the procedure to be adopted, whether national procedure for the criminal trial or an international procedure. So all these things need to be worked out. And only then the hybrid court can function. And every aspect of the functioning of the hybrid court must be worked out much before the trial begins. Because after the trial begins, we cannot deal with these problems because the trial must go on smoothly and efficiently. So there is a need for all the problems to be covered up before the hybrid court starts its criminal proceedings against an accused. Hybrid courts, as I stated, cannot be an alternative to the ICC in each and every case because every case has its own facts and circumstances. And the hybrid system may work for some cases and may not work for the others. So that is why it is important to determine first which case would be better to be referred to hybrid system and which case would not be good for the hybrid system. This initial determination of the problem must be made. And then disputes must be referred to the hybrid court. So this is what I have to say. And whether hybrid courts would be a success is an issue that can be best understood when the hybrid courts, after being established, till now, hybrid courts suggestion, a proposal, and some states have tried it, but it was not satisfactory. The court functioning was not received by the states in a wholehearted manner. They found certain lacunae and certain defects in the functioning of the hybrid courts. So these things need to be addressed. And how best we can address these is something that this particular panel should discuss at this point of time. That is my submission. Thank you.
Thank you, Professor Shivati. Excellent the presentation of Professor Chipati. I have found through the internet, and I will send it to Professor Milton so he can send the document. So we can discuss this document in a second part. It's named the CAR Guidelines on the Establishment of Hybrid Courts. And it's an investigation, a research done by Christian Einlein and Mark Kirsten, and Philip Ambach, Elena Bailes, Philip McDonald, Tijana Jana Maluwa, Angela Mudukuti. And in the preamble of the acknowledgement, there is from Stephen Rapp. Stephen Rapp, from 2007 to 2009, he was the prosecutor of the Special Court for Sierra Leone, and as he made some very interesting acknowledgement, and I want to read this part of
the United Nations.
No, it said the CAR guidelines on the establishment of hybrid courts. Yeah, I will pass it's a PDF. I just found it.
Of the tribunal, the Yugoslavian tribunal, remember?
Yes.
Yeah.
But there is a research that it's named the CAR guidelines on the establishment of hybrid courts. It's from it has the backup of the Wayama Foundation and the London School of Economics Institute for Global Affairs.
Yeah.
It was released last year. The acknowledgement, the forward acknowledgement is by Stephen Rapp. He was a former, he was a former prosecutor.
I've already looked at that document. It's very
yes, I will send it you right now.
I have it.
But yes, you have it, yes?
Yeah,
of course.
I studied it.
Yes, and what I see here, this part I want to read it about what Stephen has a point. He says, as the Rome Statute recognizes the primary responsibility of the national legal systems and admits cases at the international level, only where there is a clear necessity, the design and creation of hybrid courts should be internationalized, only on the extent required to fill specific needs that cannot be met at the national level. If those needs can eventually be met domestically, then the hybrid court should be organized in a way that facilitates a transition. It's a little bit this concept that they taught us when we took the course of international law or international criminal law. They say that the international criminal law has more of national law than rather from international law. It's more like the concept of private international, the essence of private international law. Also, I have read in the web, there's an article that explains, I have it, one moment, I have it here, and I will pass it also to Professor Milton so he can share with our viewers and our panelists. One moment, please, I have it here. It's about the author is the title is the Rohingya conflicts, and this Francisco Javier Zamora Cabot and Maria Chiara Marullo, they have a project that from the Rohingya, and they say that the Rohingya is there's like a thin line between private international law and international criminal law. So so that's the point. It's more to understand this concept that it's very in in the doctrine of international criminal law that it has more of national law rather than from international. And what I see as after Professor Shipati has explained us is that we are here in a point that I see it like a black hole. Uh, what is going on right now in the ICC? I see the ICC is going too slow for. We don't. I mean, we need. We should have a new head of the prosecutor office. We have no news about his election. Also, there in comparison. I think I have told you this before. In comparison between the ICC and the court, and the European Court of Human Rights under this COVID-19 situation, the European Court of Human Rights have excelled all these cases, uploading through mass media, Zoom, WebEx, or any other kind of system they have found for continuing the right of access to justice. But on the other hand, the ICC, I have not seen that. I have been seen only in some cases, and the other ones, they say they have made some statements that they're going to continue the hearings after this COVID-19 situation. They have more suitable things for health and other medical issues. So that's the reason that was my question. The Maduro, that's what I brought to the desk, Maduro's case, because right now that I'm here in Lima, Peru, I've seen a lot of Venezuelan persons, families, entire families that they are struggling for trying to work or doing something. Worse now that we are under a COVID-19 situation, that this country it's locked down, and they don't have any backup to afford the situation in a foreign country. And what I've been doing my research, doing some web investigations, it has I think there are like more than, I don't know, if 100,000 Venezuelan refugees here. Yes, it's amazing the situation in Peru. I mean, 2017 they decided to open the border. Many were Venezuelans came from Ecuador or Colombia because they didn't have the opportunity to stay there. So there is a lot of Venezuelan citizens here in Peru, and you understand that the many, after my research, I have learned that many arrived here walking from Caracas. I mean, it was amazing. It was an incredible exodus trying to when I saw also through YouTube interview, they say it was death or survival. So that was the reason I brought the Maduro case here, because all the South American countries that have, I mean, in their own skin, saw and live this disaster situation of Venezuela. They want justice. I mean, if we do a poll right now in, I don't know, Chile, Argentina, that there are also Venezuelan migrants, Brazil, Peru, and you make a poll, not to scholars or to ordinary people, and they will say, yeah, Maduro needs to be tried and be jailed for human rights violations. So the question here is that I bring to Professor Milton and Professor Shipati, anyone is free to answer, is under this new probably indictment that we will see in a couple of months, do you see that the victims from Venezuela will see justice prevail in the ICC, or you think that it will be needed in the short term a hybrid tribunal for Venezuela? From your own experience, Professor Chipati or Professor Milton? Professor,
So Milton's quote.
the system always chooses you first. I don't know why. It's your
All right. Thank you, Dr. Marota. I got the question that you were asking whether the Venezuelan population would be able to appreciate justice.
correct.
Justice would be yielded a product of a hybrid mechanism or through the ICC.
Correct.
My answer goes like this. A number of factors would determine really that answer to that question. The multiplicity of factors that would be put into effect to make us arrive at a conclusion as to whether it is appropriate before the hybrid tribunal or hybrid court for that matter, or whether it should be before the ICC. What really is critical here is the factors which I'm going to outline in my discourse, which people would have to take into account when they consider the possibility of having a hybrid system or mechanism to suit their circumstances vis-a-vis the ICC. So I think my answer will come in more details when I make my discourse, which will unveil a number of points that I'm going to put across. But I believe possibly Professor Sripathi has something to mention on that particular question to put across. I hand over back to you.
Thank you, Professor Milton. If I were to give my opinion in respect of the Venezuelans, whether they would like to have a hybrid court or they would like to have justice from the International Criminal Court. The International Criminal Court would be the right platform or the right forum for justice to be done to the people in Venezuela. Because it is more established. The system is in place, the jurisdiction is established by the Rome Statute for the ICC. Every aspect of a criminal court is established under ICC. So I feel ICC is better equipped to do justice to the people of Venezuela. But if the people of Venezuela would like to have a hybrid court or a hybrid judicial system, then I would not feel it is a good alternative to the ICC. Because as I pointed out earlier, there are a lot of practical difficulties that a hybrid court should overcome before it can do true justice to the people of Venezuela. Or for that matter, any other country. If requests for a hybrid court, there would be problems. Because till today, a sort of hybrid courts have been established for Sierra Leone, is one example, and then for Cambodia, and then Lebanon. So hybrid courts have not been so successful in doing justice. So I frankly feel that hybrid courts may not be successful in the case of Sierra Leone also. It is my opinion. So it would be better for them to seek justice from the international criminal. That is my opinion.
Thank you.
Thank you, Professor Sripati. Yes, I also agree with Professor Sripati, the need of international justice. Also, what we need to get in consideration in the Venezuelan in the in the in the Venezuelan case is that there we have a legitimate president, that is Guaido, that he's abroad. I don't know right now where he is. Sometimes he appears in Venezuela. Then they will Maduro will try to kill him, and he will go to other country. And Maduro is like he has doesn't have the backup of the people. I mean, he is usurpator of the power in Venezuela. So yep. Also, I agree with Professor Shipati to see international justice. So the other part that I see, and I will study maybe in another opportunity we can discuss the 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 car guidelines to establish a hybrid courts is I think it's from my point of view, and I also there is another Discourse in YouTube, and I will do the search because I saw it. It was from the Acer institution from the Netherlands. They discussed this also about hybrid courts, and this group of specialists, they were in most of them. There were like two. One of the guests was from France. The other two were American professors, and they are pro hybrid. I mean, the American scholars, they are pro hybrid justice rather than the ICC. If they also they are if they want also they are pro changing how the way the prosecutor office is run, how it's run today. They have another ideas. But the point that I want to bring here is that they have this feeling that the ICC prosecutor office, and I think we have discussed this in the past, is a little bit slow for immediately prosecuting international criminals. So they brought um, what Germany is doing with the Syrians that are with these international criminals that are in Germany, and they are prosecuted them under universal jurisdiction because they have the perpetrators and they have the victims in Germany, so they are trialing them. And because the constitution they have this their own statute that complies with prosecuting international criminals in Germany soil. So that's a little bit. So what I think after what Professor Shipati has shared with us is that we have to. Our goal is that the ICC it should be the one that will take all the international cases, and we need, as scholars from the governments, to aid the ICC to be more proactive from the from from the prosecutor office. I recall a course I made with the Andean Commission of Jurists about 12 years ago, 13 years ago, in 2007. It was, the name of the course was the Andean countries and the relation with the International Criminal Court. And one of the conclusions that we with all the panelists and the students of the course was that each country from Latin American from the Indian region should aid with the prosecuting offices from each country, from this each country, and it could be replicated to other prosecutors' office from any other countries from around the world, is that they need to have a dynamic and a very constant communication. So, for example, Venezuela, and we know that the Maduro controls all the all the the prosecutor office, the Department of Justice, everything he controls over there. So I don't know, other countries like Ecuador, Brazil, Peru, Chile, Colombia, their prosecutor office could have all the all the statements from the victims, and in such a way pass it directly to the prosecutor office in the ICC with without any challenge of for revising again the accusation. So the indictment can be made more quickly. So in that way, so it's like it's like the prosecutor office in The Hague from the ICC will use the prosecutors of these countries as an element for the investigation, and to be more proactive in for the investigation, so they can open more quickly. For example, this how many years that from 2017 it's going to be in 3 years. I mean, 3 years for the UN to get at a conclusion that was visible for every human being, that in Venezuela there were violations of human rights. They took 3 years. If they will have this idea of using the prosecutor office of the nearby countries, from the place where, from Venezuela, the nearby country where the perpetrators have been committed, these victims can make could or can make their statements over there, and then by, I don't know, by an email, by consular diplomat mail, I don't know, that will depend how the ICC will receive that information, or even though by a certificate email, by internet, will receive that, and they will have the information, and having the trust of these statements to open an investigation. And then through, now that we have Zoom, or in the past that we have Skype or WebEx, to have from the prosecutor in the Hague also trying to take the statements of the victims. So it will be, under this method, it will be short the period for the ICC prosecutors to make an indictment, and then to pass to the pretrial chambers. So that was the recommendation that we found 13 years ago, that will be very useful. But all this kind of bureaucracy from the prosecutor office of the ICC makes things too slow. I mean, we need to use this COVID-19 situation that everything is online, even though many masters of many well-known universities, they have all their masters goes to from this year and next year to be online 100%, and probably they will stay that way even though we have the vaccine against COVID-19. So because we are going to get the world more connected, and if we are getting more connected, also the ICC will need to be more connected, and trying to use the other. I mean, if you see it in thinking out the box, if you see it from a perspective of not as a legal scholar, just like I don't know, a businessman, we have all around the globe, the we have a lot of uh, available prosecutors that can make a very useful investigation and pass it very quickly to the ICC in a place where violations of human rights, crimes against humanity have been committed, rather than going all these slow elephant process of making the accusations for doing an investigation for human rights violations. So, I mean, we need to be creative. I think that trying, I mean, after we can, this COVID-19, we can use it. Okay, under this COVID-19, there are going to be future pandemics in the years for coming. We need to have a backup system that will work for making accusations and investigations for international criminal perpetrators. So I mean, this is a way for a start. So Venezuela took 3 years because there was a lot of pressure, and there was an international government from Canada with this new prime minister that was making all the lobby, all the international lobby. So the UN could end for this kind of conclusions. But we have seen other countries like Georgia, the prosecutor office took like 5 years, and it was a dead end. I mean, and we know that in Georgia there were international crimes committed. So that's the way that with that's the way that if the ICC thinks out the box and a little bit more creative, probably the hybrid justice will be using like a last resource, and all will be focused on the ICC. However, with the help of each country uh, uh, sharing the, it will be need decided by each country how many prosecutors will be part of this long arm of the prosecutor office of the ICC. For example, I know 50 that they will be the ones they will, I don't know, speak French, English, no, Spanish. That they are the Russia, I think that the court's official languages, and to do to aid, for example, I don't know. Even this, I'm bringing now because I'm having the example of Maduro. Uh, Imagine that my proposal has been accepted in the ICC for the ICC 10 years ago, and when the migration of this population from Venezuela, and they began to do their statements before, I don't know, the first country that they passed is Colombia. They made the statements over there. Then the Colombian, I don't know, they have this office of prosecutors that are recognized by the ICC. They could take the statement and then pass it to the ICC for doing the investigation. Those 3 years, it could be reduced for 6 months. So in 6 months, we will have an ICC indictment, an international indictment for international crimes. On the other hand, it's going to be too slow. It will take 3 years, a lot of lobby in the UN for having. If you check, and I give you as a homework for all the audience that are listening and all the participants. If you go to the group of Lima and you check who are the persons who are part of this group of Lima, you will see that many of them have been former ambassadors. One of them is Alan Wagner. Alan Wagner was one of the in the Court of Justice was one of the attorneys in the case between Peru and Chile. So they have international presence and they could do the lobby very, very strongly for the UN to have for having an investigation within 3 years. But that's not in other parts of the world that we know. I mean, we were lucky to, in this kind of situation of Venezuela, having these people that are part of the Group of Lima to do the statement, also have to draw back up. I don't know if in 10 or 15 years we are going to have all of that. I don't know, probably not. And we need to, like a joint venture between the prosecutor office of the ICC, more real. It's not like a statement. No, it's not like dead words in a paper. I mean, this needs to be more. It needs to be more real. So also, I bring this. What do you think, professors? That we need to this joint venture between the prosecutor office of the ICC and the other prosecutor office from the countries that are part of the Ram Statute in another horrible situation of international crime could be part of aiding the ICC more, the prosecutor office more quickly for doing indictments. What do you think?
Let's get the question again. You are saying?
Yes. I'm saying that right now there are bilateral agreements between, for example, there are bilateral agreements of cooperation between country A with the prosecutor office of country A with the prosecutor office of the ICC.
Mm-hmm.
But what I'm saying is we need to make like a joint venture where a group of prosecutors, I don't know, 100, I don't know the number, I will say 100 of this country A to be the eyes of the ICC prosecutor office. I'm in the case of Venezuela.
Okay.
If that will, yes. Because the victims of there, for example, this country B, that is the border country with country A. There has been a lot of violation of international crimes in country B. So the prosecutors here in country A can aid the ICC in taking the statements of the victims and trying to do some kind of research of that international crime. So this information of this international crimes committee goes to the ICC, and the ICC could act more quickly that it has been working in the past years.
I got your question. To answer that question, in my humble view, we need to look at when we touch the ICC, we have to understand that ICC is a creature of a statute. So in its operations, all its operations stem from, the life that is granted to it by the statute, the Rome Statute. The powers that it has, the scope of its operations, the jurisdiction are all within the statute. When we look at the statute in terms of how it relates with other countries, we would have to see first the principle of complementarity. You see, when we look at Article 17 and Article 19 that govern admissibility, would see to what extent the prosecutor would have a relationship with a nation outside, or the ICC itself would have interactions with a domestic jurisdiction outside. But then came 2006, between 2003, there were other developments within the OTP, the Office of the Prosecutor, when we had Moreno Ocampo,
yes,
when he was still the first chief prosecutor of the ICC. We recall that there were a number of policies that were passed, which gradually the prosecutor introduced policies that were towards, initially it was to make, this is actual positive complementarity that I'm talking about. So the Office of the Prosecutor came up and tried to develop the policy of positive complementarity. This particular policy could be closer to what you're trying to suggest, because this policy was such that it had to, because of the nature of how overwhelmed the ICC is with cases, we decided that they should adopt a policy whereby they have an interaction with the domestic state, the national authorities, so that what the ICC would be doing, the ultimate aim was to reduce the number of cases coming up to the ICC. And that is where Moreno Campo indicated that the success of the ICC would be judged not by how many convictions it has secured of, of those perpetrators of the crimes, but with how little, how many cases are coming up before the court. So the direction should be reversed so that the ICC should be able to support the national jurisdiction. The national jurisdiction should be supported in terms of capacity building, in terms so that, the prosecutors are well trained, the judges are well trained in matters of international criminal justice, so that they're able to deal with these issues domestically. But as you will see in the discourse that I'll have with my issue of the hybrid justice, it will come clear that there are a lot of questions that erupt out of this. Because the extent to which the ICC was to assist the national jurisdiction was such that it has no financial, does not offer any financial support, and it's not actually directly offering some kind of assistance to this, but facilitating a situation that would render the national jurisdiction being able to prosecute and investigate effectively the crimes within their jurisdiction without having to go to the International Criminal Court. But that, as we shall see, also had its own limitations and weaknesses. So just to summarize, the extent to which there can be cooperation between the prosecutors, be there 100 or how many prosecutors, would be dependent upon what the Rome Statute states, and also would have to look at what the new policy of positive complementarity, which is actually not directly, it has been argued that's provided for when we look at the, say, Article 54, I think, of the Rome Statute and other articles. There's been argument on 53, there have been arguments that somehow there's tacit provision that allows the prosecutor or the ICC to support the domestic jurisdictions. So that relationship between the prosecutors of the national jurisdiction and the international court would revolve basically around the fact that the Rome Statute should be looked at to see whether it provides for it. Because if it's not provided for, then the court's action would be, that's the difference between the ICC and other courts, which we are going to look at. Because the ICC's operations are confined within the limits of what is provided in the statute. If it does something which is not within the statute, that would be ultra-virus, to be beyond its scope. So they are careful to do all things that are engendered by the statute that brought them, the mother statute that brought them into action. Okay, on that note, maybe I need to, unless Professor Sripathi has something, I need to present my discourse on hybrid.
Yes, Professor. You're welcome.
Thank you, Professor Milton. And I totally agree with Professor Milton on this issue, because for the International Criminal Court to take a step of cooperating, the prosecutor's office cooperating with the prosecutor of Venezuela, that matter any other state that refers a case to the International Criminal Court, is something that just does not happen like that. Because first of all, the Rome Statute should provide for it. Is there a provision in the Rome Statute for cooperation between the Office of the Prosecutor and the Office of the Prosecutor in the country that has referred the case to the court? Now, when we speak of the principle of complementarity under the Rome Statute, it merely says that where if a court, where if a state is not able to punish or try the accused person, or intentionally the state does not want to try the accused, then the ICC will step in. But the principle of complementarity does not speak of such a cooperation between the prosecutor of the International Criminal Court and the prosecutor of the national courts of the country which has referred the case to the ICC. Now, speaking of Venezuela, the main drawback with the International Criminal Court and many states which are parties to the court have felt that things move very slowly in the International Criminal Court. We have seen the case of Afghanistan, which nearly took 10 years, I suppose, for the court to respond. And now, if the Security Council makes a referral, then it need not, that is, the prosecutor need not take the consent of the judges of the pre-trial chamber. The prosecutor can straight away start off an investigation. But if the prosecutor has to start an investigation on his own, voluntarily, then he needs the permission of the pre-trial chamber, and that will take time. And that is one of the biggest drawbacks, and states refuse to refer the cases to the court because of this delay in the prosecutor taking up an investigation. Now, if you see in the case of Venezuela, Venezuela did not refer the matter to the ICC. 6 other countries have referred the matter collectively to the ICC. So, this is for the first time a multilateral referral has been made to the ICC. 6 countries together jointly have referred the crimes that have been committed in Venezuela to the International Criminal Court. So this multilateral referral would mean that the 6 states that have made the referral are actually supporting the cause of Venezuela and also the court. Politically, they are ready to support the court. So the court can immediately take up an investigation, empowering the prosecutor to start the investigation without going through the permission being granted by the pre-trial chamber because of the multilateral referral that has been made. That is my opinion. I do not know how the court will act or the judges in the pre-trial chamber might take it. But there is support of 6 countries for an investigation. So the pre-trial chamber should not waste any time and then immediately order an investigation, and the prosecutor should take up the investigation. So I still feel the ICC is a better option than hybrid courts. That is my opinion.
All right, thank you, Professor.
Thank you, Professor Tripathi.
That is great. Just to add on to that, when we have the 3 mechanisms, the 3 trigger mechanisms for that matter, if it is the Security Council referring the matter to the ICC, at least the process is faster. It wouldn't require a lot of elaborate, it's just a formal procedure for the prosecutor to initiate proceedings. We also, when we have the state party also referral.
State referral.
Sorry, state referral, that's right. It would also not entail a lot of complication. The complications arise where the prosecutor pro motu wants to start it. There's a lot of complication. or because when they start, they want to start it, there would be admissibility issues also concerned. And even when there's a state referral, once there are admissibility challenges, it's the question of admissibility challenges that may be a problem before the, but usually when there's, this would wrapped under proprio motu, when the prosecutor feels that in her possession there's sufficient evidence to undertake an investigation. All right, I hope now Dr. Marota and Professor Sripathi, you'll allow me to make a presentation.
Yes, of course, Professor, continue.
Yes, yes.
All right, just before I start, we have Brenda Grace, who has just sent me a message that she's following the discourse. She's attending to some patients within her place, so she may not be able to appear visually, but she's with us. She's critically following the proceedings. All right, this is how I'm going to approach my presentation. I will first look at, because the whole point is about hybrid justice vis-a-vis the ICC. We're trying to look at, to have a comparative analysis, contrasting analysis between the hybrid mechanism and the existing International Criminal Court system of justice. This is how I intend to approach it. I will look at the main features of the hybrid justice system, the mechanism under which this system operates, under which the hybrid justice is meted. And after that, I will go into, I will actually have a cursory look at almost 9 hybrid tribunals that have been set up. I'll go very, very fast over them, look at the features and the particular characteristics of each of them. As we said in retrospect, a hybrid is a combination of 1 or 2 systems or things for that matter. And in our context, the hybrid justice is a system that brings in the international criminal justice system and the national criminal justice. So it is a mechanism that combines both of these systems. But what is involved in this? This is what we have to look at. We're going to examine the jurisdiction. That is a key issue here. The structure of the institutions that are going to conduct or the affairs of this, of the mechanism itself. And we'll also look at the operative law, the procedure and evidence that is applied, and a number of other issues such as funding of the institution. So first, as we can say, it's a combination where the mechanism takes into account the international criminal justice as we know it, and putting it together with the domestic system that is in place. But just as Professor Sripathi put it, it brings in a lot of challenges. When you try to fuse these 2 systems, the immediate challenge we find out is that there will be a problem over the supremacy of, when the dominance of the national law, the municipal law over certain, there'll be a clash between, because under certain ingrained systems, there's no way we could have an international law being applicable easily within the domestic setup. There could be a lot of confusion within, in terms of how that particular law would be adaptable if it's in conflict with the already set up system in the country that does not allow other systems to come in. That is really a challenge that will be posed depending on which state. It may not be a challenge in other states, but I think that was a very valid point that the professor raised. So this system, the mechanism is conducted through courts. They are also called panels or tribunals for that matter, depending on which state and the language that is picked. But essentially the intensity and direction of all these systems or mechanisms is to seek to afford justice to the victims and to be able to hold the perpetrators to account. And the key thing as well about it is that this hybrid justice system are largely characteristic of transitional societies, the societies that are post-conflict, that are emerging out of conflict, communities that have been traumatized by atrocity crimes, largely atrocity crimes, And so there's need for them to be able, we need to have restorative justice installed or instilled within such societies. And to an extent reparative, to be able to carry out reparation, which has challenges, as we shall see as well, when we look at the issue of hybrid justice. There's a big challenge in terms of reparation, as we shall see. It's a broader challenge that relates to finances, the financing of the system itself. As we can see, the ICC itself is now almost struggling also with financing and challenges. All right, so these tribunals or institutions are ordinarily based within the national jurisdiction, within the territory that requires justice. However, we have exceptions, like what we had in Senegal, Dakar, where we had a tribunal set up, as we shall see when I rush through each of the tribunal, set up to deal with the former president Hussein Habre, who was actually a leader in a different country, but had to be tried in a separate country. That was between an agreement between the AU and Senegal. But by and large, the hybrid justice institutions are normally ordinarily set up within the domestic, within the territory of that particular country or state that wants to carry out the justice system. The key features that we look at, I'll pose these features in form of, in a way that they'll provoke thought and introspective analysis. I'm just going to put them across to enable critical thinking among the panelists and even the viewers, so that they're able to make their own interpretation of what the characteristics are. Let's look at the issue of, we have already said that restorative justice institutions are set up in the institution, in the domestic jurisdiction, and in the form of courts or tribunals or any other, structure that will be able to dispense justice. But we have to look at one thing. What is the operative law? What operative law governs the way the hybrid justice institution conducts itself to arrive at justice in a given circumstance? So as already put by Professor Sripathi, it's both. As the hybrid suggests, it's hybrid also in terms of the operative law. It puts into combination the law of the municipal law, the local criminal law, the penal code that we have locally. At the same time, it applies also the international law, the laws of international humanitarian law, actually international humanitarian law, the violations, if they relate to those, all those are put in combination. In other words, the kind of crimes that come before this particular hybrid tribunal may go beyond what is just available within the penal code. As we know, most penal codes of most countries do not take into account atrocity crimes. Most of them do not have or had not had crimes of genocide, crimes against humanity incorporated within their penal codes. But the hybrid jurisdiction, the hybrid system or mechanism allowed for those kind of crimes that were not catered for within the domestic jurisdiction to be brought into within the purview of the administration of justice. So that's very critical. The operative law is not just the international law, it's not just the national law, but it's a combination of both the national law and the international law to be able to afford maximum justice, maximum impact of justice, to allow for accountability, and to be able to also afford deterrence so that impunity could be arrested. Okay, well, the question would come, why would we really have, okay, the other, before I pose that question, is the structure. The structure in all these points that I'm mentioning, there is hybrid, there is a mixture, there's a combination of both systems, national and international. When we look at the structure of the hybrid courts, we look at how it's formed. We have the judges. They're not all the same. The structures vary between, we'll see variations as I go through the various hybrid courts. or countries that have been able to exercise this kind of mechanism, the structure are not necessarily identical. They're a bit different in each sense, but all of them more or less, more or less the same. We'd have a structure where the judges, we have local judges, national judges, sitting along with international judges. Depending on the agreement that has been arrived at by the nation and any other entity, the number of judges, there could be more international judges sitting in a hybrid tribunal than the national judges. We have instances where we have more national judges than the international judges, but that will be explained as we go on. The essence is, in the long run, we should have more of national judges just to allow for acceptability of the institution locally. But we can see, the question that I wanted to pose is, why would we really have international judges coming to preside over cases where we have national judges too? There are a number of factors. It's up to you to draw your own conclusion and reasoning. There are a number of factors that will lead to this. One, there could be the issue of integrity of the process. There would be need to see why we cannot just afford to have the local judges. There's an element of distrust here. Possibly the local judges can easily be influenced by the powers. We know that there are real powers, political powers within a state. And there is the risk of bias in terms, as we shall see in one of the rulings in one of the tribunals, where all the international judges are ruled to be able to convict, while the local judges were there to acquit. So it is like a check system. So that points towards one of the advantages or the virtues of a hybrid system, to be able to afford genuine justice in a given environment, to be able to assure the perpetrators, the victims, that the perpetrators would be held to account. Because ordinarily the international judges would have no interest locally. Really, they would not have any political interest. They're sort of impartial in the way they look at issues. But it's very hard to find a judge who is totally impartial while he's the national of a country. One way or the other, there are factors that sway them, either fear or favor for that matter. Okay, so the structures, in all these structures, whether we have pretrial, chamber, trial, and appeal, in most of the courts that we're going to look at, you find that there are international judges that are appointed. That depends on the kind of statute that has brought that particular hybrid court into existence. It could prescribe a higher number of international judges, but we have cases, in very limited cases indeed, where we have majority of the national judges. But what we know is that gradually with time, there should be movement where the national judges eventually become more to take over, to give it the local identity, where there's been assurance really that now the system is in control. Okay, the other thing that we look at, apart from the judges, also the prosecution office is very critical. Most of them, you'll find that the prosecutor, the chief prosecutor, is an international prosecutor. It's appointed internationally, maybe by the UN or by any other body depending on the statute, while the deputy is a national prosecutor. That is just a way to ensure that there's control, there's no bias, and integrity of the process is taken into account. And the rules of procedure and evidence is also critical. As we said, the operative law, the substantive law that governs the whole proceedings would have to be a combination of two. And it follows, therefore, that the rules of procedure and evidence would also have to fuse these two systems, the national and international system. Now, let's look at the jurisdiction issues. The issues of jurisdiction are very critical. There are questions that have been raised by both Dr. Marotta and Professor Sripathi in a way, but the issues that revolve around jurisdiction. When we talk about the ICC, the questions would be, where does complementarity apply? How does it apply with respect to a hybrid jurisdiction? Because we know the International Criminal Court, as well explained by Professor Sripathi, would intervene only where the domestic jurisdiction, the primacy actually is upon the domestic jurisdiction, where the domestic jurisdiction either is unable or unwilling to be able to investigate or prosecute, or if they prosecute, they're just carrying out a sham prosecution to cover up their cronies. So there's no genuine prosecution. It's sham. They actually prosecute. You see that they're prosecuting, but they're sure of the outcome, that they would acquit their allies just to be able to prevent the ICC from intervening. So the question here is, to what extent would the relationship of complementarity apply in the case of hybrid jurisdiction? Can we say, what is the relationship between the hybrid courts and the ICC in case of a matter which is now being handled locally? Should we say, can the ICC attempt to take over a matter that is being handled by the hybrid jurisdiction, a hybrid mechanism, if it is convinced that probably it's not properly being handled there? Is there such possibility? That's a very vexing question, because when you look at the statute, it's ordinarily a relationship between the state and the ICC. It's where the state itself fails or actually is unwilling or unable to prosecute. But here's a case where we have a hybrid. There are elements of international personalities within the hybrid institution. So where does complementarity come in? That has really posed a lot of complications to many scholars and academics and practitioners of international criminal law. I leave it to you to be able to look at it and decide for yourself what would be the case. For instance, would the ICC demand that a particular suspect be brought before it when it sees that justice may not be dispensed in a hybrid setup? That's a question of jurisdiction or concurrence. So which one are the jurisdictions concurrent between the ICC and the hybrid tribunal? What is the state, what is the nature of the jurisdiction of both of these institutions? Is it concurrent? Is it a question of primacy within? Does the hybrid mechanism jurisdiction, is it having primacy over the International Criminal Court? That's a question that needs to be addressed. We need to look at that. So apart from the jurisdictional issues that we've talked about, there's also the issue of the temporal jurisdiction. The duration of there is the common element that runs through all these hybrid institutions. Most of them were ad hoc. They were actually established by, some of them by the United Nations involvement, some of them between the AU, as we shall look at very quickly. And unlike the ICC that was established by way of a statute that gives it permanency, it's a permanent institution. But most of these hybrid jurisdictions have a limit. There are times that they phase out. And actually, what people, the common thinking was that since, the hybrid jurisdiction is not something that is new, it has been existing even before the ICC itself fully came into operation. And there was hope, or there was a thinking that the more the ICC now entrenches itself, the hybrid jurisdiction or hybrid system would be phased out. It would be a relic of the past prior to existence of the ICC. However, we are seeing more and more of the features of hybrid jurisdiction coming up, with people realizing that the ICC, the lofty dreams they had about the ICC, are not being fulfilled. The ICC has been in existence for a number of years, and you can count only a few cases that have been finalized. And the expenses have been vast and prohibitive. And it has come along with it a lot of resistance from other nations. Acceptability is a problem. There are political factors surrounding it, its operations, rejection by a number of states. So people are beginning to see that. We know recently we just heard how the US termed the ICC a kangaroo court. So there are a lot of limitations and constraints within the ICC. And people are beginning to reevaluate the approach and say, really, don't you think the hybrid mechanism was more acceptable and it delivers justice much better and faster than the ICC. In any case, an event is located within the jurisdiction, within the territory where these crimes are committed. It's easy to locate the witnesses. The evidence can be found easily. It's more acceptable to the national people. They can see that the perpetrators are being, prosecuted. There's more accountability. So that's the issue of, I'm trying to look at the ICC and how people began to revert, to reevaluate the need for the hybrid jurisdiction. So we now begin to see more and more hybrid jurisdiction coming up, hybrid institutions such as the one in Kosovo, specialist chambers and the specialist prosecution office, which has just come up lately. All right, the other thing that we have to look at is, apart from the temporal, we need to look at the territorial one, which I already mentioned, the jurisdiction. Ordinarily, the hybrid jurisdiction would be exercised. A hybrid institution or mechanism would be within the territory where the crimes were committed. Let's say if it is Uganda, that is where it would sit. However, we have certain cases, as I gave the example of Hussein Hebre, who was being prosecuted in Senegal, in a different country from where the crimes are committed. That would depend on the kind of agreement that is arrived between the states themselves. All right, there are issues that come up. How do we finance a hybrid institution? Where does the finance come from? Most of these finances have been coming from voluntary sources, from people, giving donations to be able to sustain them. And that has led to a lot of insecurity in terms of operation, because there are a lot of anxiety as to whether it's able to exist and for how long such institutions would be able to exist. Because ordinarily those institutions are funded from external sources, because here we are dealing with post-conflict institutions. We are dealing with transitional institutions, societies that have just emerged from very difficult situations. And most of the time, they are financially handicapped. Okay, those are key points that we need to look at. And apart from that, there is the issue of, after the conviction, when the sentence has been arrived at, the issue of sentencing and actually the issue of serving sentence. That goes without saying that ordinarily the sentence will be passed and the offenders convicted would be, would serve their sentence within the domestic jurisdiction. However, it will also depend on what sort of agreement exists between the state and that particular institution, how the involvement of the international personalities and the international intervention will determine also how the punishment where the convicted persons would serve their sentence. Right, the number of the features we look at as we go on, but now I very quickly want to rush you through some of the hybrid institutions, and this will bring out the points that we're talking about. First, we have a look at the extraordinary chambers in the court of Cambodia. This one is still existing. It was established in 2006, and it is still existing. It was established by virtue of the United Nations Security Council Resolution 57/228, which was passed in December 18th, 2002. It is concerned basically violations of international humanitarian law, as I said, and aspects of the Cambodian law, that the violations that took place between 1975 and 1979. Within these 4 years, there are a lot of traumatic experiences that went on within this country that required to be redressed. So this particular chamber, upon the resolution of the UN, we can see the UN resolution is the basis of its existence. And the expenses of these particular chambers were borne by voluntary contribution from the international community, as I said. They're not funded by the domestic government. So it was an agreement between the United Nations and the royal government of Cambodia to be able to prosecute under Cambodian law the crimes that were committed by the democratic Cambodia. This was the agreement of the ECCC, actually ECC, the extraordinary chambers in the court of Cambodia. So the agreement, this particular agreement allowed for a fusion, we can see. The hybrid nature is the Cambodian law, the penal law that governs the aspects of crimes that were committed. But as we indicated earlier, the violations of international humanitarian law would be some aspects that are not catered for within the penal code. Like I said, most penal codes, national penal codes, do not have provision for genocide or aggression or war crimes. So that is where we bring in the international aspects of operative law, with a lot of challenges, as Professor Shilpathy put it, with a lot of challenges on how the validity of these particular laws would apply domestically. So the internal rules of ECC were adopted in 2007. And of course, the jurisdiction, as I said, involved, it was to deal with very senior, such courts, normally the hybrid would not deal with virtually every other culprit or perpetrator of the crimes. Just like the ICC, they would tend to go for the key perpetrators, the senior persons or the leaders, like in this case, the leaders of the democratic Cambodia, were being held to account. And there's also the structure. It had the structure of the victim support section and the defense support section, just like we had in the tribunals, the ad hoc tribunals and the ICC. So this particular hybrid system had the victim support section as well as the defense support section. The chambers that were set up were pretrial chambers that would be able to look at the issues. The pretrial chambers were a mixture of both the local and international judges, the trial chambers, and the Supreme Court. We had the prosecutor as well. The prosecution office also had a hybrid characteristic with the international prosecutors and the national prosecutors. This particular one had a structure. We have systems that adopt a way of having investigating judges at that level. Before the matter gets down to full trial, we have investigating judges. This is one other case where we had investigating judges. And the same case also we had international judges as well as the local judges prosecuting. That's all I can mention about the Cambodian. Let's look at quickly, we look at the features of the Extraordinary African Chambers, the EAC. This one has already ceased to exist. This was formed in February 8th, 2013, and it stopped operating in April 2017, just about 4 years. It was meant to try in Chad. It was meant to try, actually it was based in Senegal, but it was meant to try the atrocities that were committed in Chad as we can see, it was an agreement between the AU, the African Union, and the government of Senegal to be able to hold one particular person to account. And that was Hissène Habré. And that was done at the Dakar. Hissène Habré is not a national of Senegal, but by virtue of the agreement, this is one exception, as I said, that the hybrid mechanism need not be exercised in a domestic establishment. It could also be established in a different country depending on the agreement that has been arrived at. So here we have Hissène Habré was formerly the president of Chad, and having committed a lot of atrocities, crimes of rape, murders, they decided to have him prosecuted in a different country, and that was in Senegal. And in that particular country, we had the Senegal Court of Appeals, the Senegalese investigative judges as well, and we had African Union judges, 2 African Union judges presiding. Apart from that, we also have the Iraqi High Tribunal that ran for almost 2 years, between 2005 and 2006. Here, the founding document basically was, we had the law of the Supreme Iraqi Criminal Tribunal. You see, when Iraqi had gone through all these processes, the aim of this particular tribunal was set up principally to deal with Saddam Hussein and his henchmen. You see, sometimes some of these tribunals would be set up with a particular target. Like we can see the Senegal one was to handle the issue of the dictator Hissène Habré. This particular one in Iraq was designed to deal with Saddam Hussein and all his henchmen that were involved in dictatorship and the murder of the Kurds and all these members of the Ba'ath Party who were involved in atrocities, the serious crimes. And we can see that these crimes were backdated from July 1968. Imagine, 68, and the tribunal was set up in 2007. It was backdated retrospectively from 1968 to 2003. So this one generally dealt with the issues that Saddam Hussein carried out. And we can see that what happened in the end, Saddam Hussein was sentenced to die by hanging by this particular institution. All right, apart from that, we have the Kosovo Specialist Chamber, which I said is a new one that was set up in 2017 and still exists to date. And this particular one is existing. It is set up by virtue of some agreement. It has been now set up in the Netherlands, next to the Hague, within the Hague, next to the ICC. Basically, this deals with the issues that happened in Kosovo, as we all know, and the hybrid nature of its operations is such that both it engages international and local lawyers. Quickly, number 5, we have the Specialist Court of Sierra Leone. That court that existed between 2002 and 2012. When it ceased, we had a residual mechanism, which is the Residual Special Court for Sierra Leone, which is from 2012 to the present day, which is still existing to date. So that one has to deal with the United Nations Security Council resolution that led to its formation. Again, as we see, most of the jurisdiction is a combination of the two. It takes into account the operative law that operates in the country and the international law. We have the Special Criminal Court in the Central African Republic. That one was formed in 2015 and exists to date, looking into the violations of international humanitarian law that occurred in the Central African Republic. The same thing, violations of international humanitarian law being governed by international law in place that are not provided for by the local institutions of the local legal framework. We have the special panel of the Dili District Court, which existed between 2002 and 2006. That one deals with the East Timor. It was set up by the United Nations transition of East Timor. The Indonesian government signed a memorandum of understanding way back in 2000 that led to its formation. Again, here we see that the aspects of international criminal law comes in. which were not hitherto provided for under the national jurisdiction. So we have a tribunal that exercises jurisdiction over both operative law in the country and fusing it with international humanitarian law to be able to make justice in the circumstances. Then number 8, we have the Special Tribunal for Lebanon, which existed from 2009. We know of the case of Rafik Hariri, and we can see the motivation for assassination of this particular prime minister led to the formation of this tribunal. Specifically, it was designed to deal with that particular incident that was carried out where Rafik Hariri was murdered along with a number of other persons. So the jurisdiction again exercised included the attacks that were carried out between 2004 October and 2005 December. And finally, among the ones we have War Crimes Chamber in Bosnia and Hezegovina. That was established in 2005, March 9th, to the present day. There has been no time limit for the mandate of this particular tribunal. And the founding document was promulgated way back in 2000 actually, November 2000. It took almost 5 years for it to come into operation. Again, as we can see, the jurisdiction is such that it deals with matters which you find that were not hitherto provided for. We know that there's the ICTY that was handling concurrently similar issues, the International Criminal Tribunal for former Yugoslavia. But this particular one focused on a more hybrid approach to dealing with the matter, as opposed to the ICTY that was wound up, of course, as we know, under the residual mechanism that came up. So in a nutshell, that's just a run through of the current hybrid institutions that we have that undergo the mechanism that characterizes the hybrid justice. So the question is, why are we now refocusing? What is the motivation for the refocus onto hybrid mechanism to achieve justice for the traumatized societies, post-conflict and transitional societies? What is the motivation? But as we said earlier, looking at the lofty goals that were set up for the ICC, the expectations were very, very high, and those expectations have been disappointed. One, the rate at which the ICC is dispensing justice is dismally disappointing. It has not been able to deliver justice as fast as would have been expected. And when we take into stock, there are only a few cases that have been finalized at this point. And we can see the burden is already overwhelming onto the ICC. And so apart from that, the general acceptability of ICC has been in question. We've had a number of complaints, like the African states wanted to abandon, to resign en masse from the Rome Statute and form their own system. We have the protocol, which is looking into the issue of setting up an African court. Actually, the African court exists, but trying to adopt the criminal jurisdiction for it so that the criminal cases which are being dealt by the ICC could be dealt with by the African court. That's just one example. We have the United States that has just issued warnings and has rebelled, has come up openly against the ICC, and a number of other countries. So ICC is faced with this Bedeville with a lot of challenges, and people are trying to look towards other direction to see how best justice can be meted in the circumstances. And so at the moment, there's more focus on hybrid justice, but we see that people are not giving it so much attention. And now there's a question as to how do these systems work? How does the hybrid system operate? How best can it be made to achieve more effective justice? These are the questions that have been asked. What are the challenges? What are the constraints that this system pose to us? What challenges do they pose? What opportunities do they present? And how can these challenges be met and be resolved so that it makes these institutions more effective? The common thing that runs through them is financing. Just the same issue that the ICC faces. Most of these hybrid institutions are financed by voluntary contributions from outsiders, and that is really a challenge. But we know that so far the hybrid system offers better justice in the circumstances, depending on the given circumstances. And there are areas it has completely faced challenges. So that is all about the hybrid system from me. And it's just a matter of provoking thought and to be able to look at the issues I raised, the issue of the relationship, jurisdictional relationship with the ICC, whether complementarity, how does complementarity fit in on the issues of hybrid jurisdiction, and also the issue of financing, all those other issues I've raised, and the issue like what Professor Sripathi raised about how to be able to inculcate in the operative law the international aspects, the international substantive law within the local jurisdiction. So thank you very much. I have to rest my discussion, my discourse at that point, and hand you back to Dr. Marotta. Thank you, Professor Sripathi, and thank you, Dr. Marotta. And thank you, Brenda, Council Brenda, for listening in the background. You are.
Yes. I was. I have been trouble with my internet connection. It was saying it was having some trouble, some message from the Zoom. So I was cutting up a little bit the video, cutting up a little bit putting the mute because it was unstable. But I'm here. Okay, thank you, Professor Milton.
Yeah.
For your great explanation.
That's almost the end of the discourse actually.
Yes. Thank you very much for that great intervention. It was very clear at the point out of what we are discussing now. I think we could make another hybrid justice versus ICC part 2, analyzing. If you can share with Professor Sripathi the document that we have in hand, that is the Dakar guidelines. We can make a discussion about the Dakar guidelines on the establishment of hybrid courts. We can make another discourse about that. And so, because it's a very interesting issue about hybrid justice courts for international justice. So, so very good for your intervention. Thank you, everyone, for participating in today's meeting, hybrid justice versus the ICC. Probably we will be adding to our webpage or through our social medias the future discourses that will come in the coming weeks. And thank you, Professor Sripathi, for your excellent interview, and also thank you to you, Professor Milton, for your excellent explanation about how it works and how it operates these hybrid courts during these years and all the examples that you have made for us. Thank you, everyone. I pass the desk to Professor Milton for the last words.
Thank you very much, Dr. Marotta, for a wonderful, powerful hosting, and thank you, Professor Dr. Sripathi, for that very excellent presentation, as usual. Thank you, Council Brenda, for following the discussion, the discourse in the background. And we hope to see you next time. Thank you, all our viewers, for being able to follow these proceedings. And we say bye-bye. We hope to see you again next week. And thank you
next week.
so much.
Next week.